Yeah, in today's class we will start with the labor laws, important है from the examination point of view. So we have Factories Act, we have Gratuity Act, and we also have the other few labor laws which are in your syllabus. We will discuss one by one in detail. Okay, so in the Factories Act 1948, if you observe the year of the act, this is one of the oldest law. This was made post independence, immediately post independence. So the act year is 1948. What is the purpose or the object behind enacting this Factories Act 1948? The purpose of the Factories Act 1948 is to provide certain basic measures to the people who works in the factories or the workers who work in the factories. Like we have health measures, we have the safety measures, we also have the welfare measures which are to be taken by the employer of the factory towards the employees. So the Factories Act provides certain measures to be taken by the employer towards the employees engaged in the factories. That measures we can classify into three categories. First one is welfare measures, second one is safety measures, and the third one is health measure. Along with that, we also have a provisions with respect to hazardous process, like what activities are considered as hazardous process. If a factory want to carry out any hazardous process which involves dangerous substance or which may cause an harm to the society, then what is the approval required or what activity should be taken? All those things we will discuss in this chapter called Factories Act 1948. So let us discuss this. There are several legislations which regulate the conditions of employment, work environment and other welfare requirements of certain specific industries. The Factories Act 1948 enacted to regulate the working conditions. Important, this law has been enacted to regulate the working conditions in the factories. In the case Ravi Shankar Sharma versus State of Rajasthan, Ravi Shankar Sharma versus State of Rajasthan, the court held that Factories Act is a social legislation. What legislation? Social legislation. They may ask in the examinations. Factories Act is what type of legislation? It is a social legislation to provide the social betterment of the employees, which provide for the health as well as safety, welfare and other aspects of the workers in the factories. So it provides for the health, as I said, health measures, safety measures and the welfare measures. Okay, so it deals with health, safety, welfare and other aspects of the workers in the factories. In short, the act is meant to provide protection to the workers from being exploited by the greedy business establishment and also provides for improvement of working conditions within the factory premises. So this act, which act? Factories Act, regulates the working conditions of the employees in the factories. It's a welfare legislation. It provides for health, safety, welfare and other aspects of the workers in the factories, not in other industries, only in the factories. The main object of the Factories Act 1948 is to ensure adequate safety measures. What measures? Adequate safety measure, and to promote the health and welfare of the workers employed in the factories. So this provides adequate safety measures and promotes health and welfare of the workers employed in the factories. The act also makes provisions regarding the employment of women as well as the young person and annual leave with wages. So in total, this chapter contains safety measures, welfare measures, then health measures to be taken by the employer towards the employees. It also provides the provisions with respect to the employment of an young person, then woman, and also the leave with wages when an employer is liable to pay the leave with wages. The act extends to the whole of India, including Jammu and Kashmir. There are no exceptions now. All the laws made by the parliament are applicable to even Jammu and Kashmir. The Factories Act 1948 extends to all of India and came into force from the date 1st April 1949. Law was made in the year 1948, but it came into force from 1st April 1949. Important definitions. Important here. First one is competent person. Who is competent person? So this definition of competent person is required to carry out any investigation. See, wherever there is a alleged violation of labor laws or alleged violation of hazardous process, then inspector may appoint a competent person to carry out inspection in that factory, where that inspector can, the competent person can take that samples, examine and can give a report. So who is a competent person? Section number 2 subclause CA defines the word expression competent person with respect to any provisions of this act. Means a person or an institution recognized as such by the chief inspector. He is a person or an organization recognized by the chief inspector for the purpose of carrying out test, examinations or inspection. Type: test, inspections or examinations are required to be done in the factory under the provisions of this act, having regard to the qualification and experience of person and facilities available at his disposal, or qualifications and experience of persons employed in such institutions and facilities available therein with regard to conduct of test, examinations and inspection. So competent person means any person or institution who is recognized as a competent person by the chief inspector under the Factories Act for the purpose of carrying out type, test, inspection, examination to be carried out. While recognizing a person as a competent person, the chief inspector shall have a regard to the qualification of the person as well as his experience and the means available with him to dispose or discharge his liabilities or obligation. Then we have hazardous process, important because a child cannot be employed in hazardous process. Even a young person, that is a person who is above 14 years but below 19 years is considered as young person. Sorry, 18 years is considered as young person. A young person is not allowed to work in the hazardous process. Now, what is hazardous process? First of all, hazardous process means any process or activity with respect to an industry specified in the first schedule. So we have a first schedule which provides the list of hazardous industries like cement manufacturing and cold storage industries are considered as hazardous industry, okay, which are specified in the first schedule, where unless a special care is taken, means if there is no special care is taken, then the raw materials used or the intermediate product or finished products or the byproducts or the waste or effluents thereof would cause material impairment. Most important, material means significant impairment to the health of the persons engaged in or connected therewith, or results in the pollution of the general environment. Either it will cause a material impairment to the health of the persons engaged in or connected therewith, or results in the pollution of the general environment, then it is considered as hazardous process. Okay. So now, what are hazardous process? Means any manufacturing. Hazardous process means any process or activity which are specified in the first schedule to the act, and where if there is no special care is taken, the raw materials are the intermediate products, are finished products, are its byproducts, are any effluents, are wastages. They may cause a material impairment to the health of the person engaged in the process, or which may results in the pollution of the general environment. Such kind of process is considered as what? Hazardous process. What process? Hazardous process. Are we clear with this? Are we clear with hazardous process, everyone? We have discussed two definitions. One is who is a competent person, as well as we also discussed the definition of hazardous process. Then we have manufacturing process. So manufacturing process means any process for making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise treating, adapting any article or substance with a view to its use, sale, transport, delivery or disposal, pumping of oil, water, sewage or any other substance, generating or transforming or transmitting the power, composing of types of printing by letterpress, lithography, photogravure or any other similar process or book binding, constructing, reconstructing, repairing, refitting, finishing or breaking up ships or vessels, or preserving or storing any article in cold storage. All these are considered as manufacturing processes. Means nothing but it's a process by which the identity or the form of the goods is changed, or there is any substance is added or value is added to the product. It is considered as manufacturing process. You may not be converting it. Let's say you keep the goods in a cold storage. That is considered as manufacturing process. Okay. Yes. In the Mr. Quasi Nurul's Hassan Hamid Hussain Petrol Pump versus Deputy Directors Employee State Insurance Corporation, it was held that manufacturing process does not depend upon and is not correlated with any end product being manufactured out of manufacturing process. It includes even repair, finishing, oiling, cleaning process with a view to its use, sale, transport or delivery or disposal. Even cleaning it or finishing it or oiling it is also considered as what? Considered as manufacturing process. It can't be restricted an activity which may result into manufacturing something or production of a commercially different article. A manufacturing process cannot be interpreted in a narrow sense in respect of an act which is meant for the purpose connected with the social welfare. So any process which were involved in printing or changing, modeling or oiling, all these are considered as what? Considered as manufacturing process. Next one, worker, important hai. Worker means a person who has been employed directly or indirectly or by through an agency, including a contract, with or without the knowledge of the principal employer, whether for remuneration or not, in any manufacturing process. That is why this manufacturing process is important. Or in any cleaning any part of machinery or premises used for manufacturing process, or in any other kind of work incidental to or connected with the manufacturing process, or the subject of manufacturing process but does not include any member of what? Armed forces of the union. It does not include the members of the army, so they are not considered as a worker. So any person who is employed either directly or through a contractor or an agency to carry out the manufacturing process or to cleaning up that machinery used in the manufacturing process is considered as a worker. Factory is important. Definition of factory: any premises including precincts thereof. Precincts means attachment thereof, whereon 10 or more workers are working. So 10 or more workers are working or were working past on any day preceding 12 months, and in any part of which a manufacturing process is being carried out with the aid of power or is ordinarily so carried out. Power means here electricity. Okay, so if a manufacturing activity is carried out in a factory having 10 or more workers in the preceding 12 months, that is considered as factory. If it is a premises where a manufacturing activity is carried out but the number of workers is at least 20 or more, then it is also considered as factory. So first one is for with the aid of power, means you are using electricity and you are carrying out the manufacturing activities. If it is not, if you are not using the electricity and carrying out the business activities, in that scenario you will be considered as a factory if there are 20 or more workers working on any day preceding how many months? Preceding 12 months. Okay, but does not includes the mines subject to the Mine Operations Act 1952 or a mobile unit which belongs to the army. For computing the number of workers, for this purpose all the workers in different goods, different groups and relays in a day shall be taken into account. For the purpose of this class, the mere fact that electronic data processing unit or computer unit is installed in any premises or part thereof shall not be considered to take into a factory if no manufacturing process is carried out. That is why manufacturing activity should be carried out in a particular place. In the Sealant versus Presiding Officer, it was held that under section number 2 clause M, factory means any premises including the precincts thereof in which a manufacturing process is carried out, sets out that mere the fact that electronic data processing unit or computer unit is installed in any premises or part thereof would not render a unit into a factory if no manufacturing process is carried out. So having number as well as carrying out manufacturing process with or without the aid of power, both are important. Okay, so if it is with the aid of power, then 10 or more workers are required in the preceding 12 months, and if it is without the aid of power, there should be minimum 20 workers who are working in that manufacturing process in the preceding how many months? 12 months. And once the act become applicable, it is always applicable. Once applicable, always applicable. It continues to be applicable. That is how this law works. Once applicable, always applicable. So once the law becomes applicable, it will applicable even if the number of workers are reduced below 20 or below the 10. Then we have definition of occupier. Definition of whom? Occupier, because it is the duty of the occupier to provide the safety, health and welfare measures to the employees or workers. An occupier of a factory as a person who is ultimate control over the affairs of the factory is considered as what? Considered as the occupier. Whoever has an ultimate control over the affairs of the factory is considered as what? Considered as an occupier. In case of a firm, that is in case of partnership firm, association of individuals, any one of the individual partners or members shall be deemed to be what? Occupier. In case of a company, any one of the directors shall be deemed to be what? Occupier. In case of factory owned or controlled by central government or any state government or local authority, the person or person appointed to manage the affairs of the factory by central government or state government shall be what? Occupier. In case of a ship which is being repaired or in which maintenance work is being carried out in a dry dock. Dry dock means, let's say when the ship is supposed to be repaired, they bring it to a dry dock. Dock means where the ships are stored. Then the owner of the dock shall be deemed to be the occupier for the purpose of any matter provided by under section number 6, 7, 7A and 7B and 11 or section number 12. For other matters, the owner of the ship will be considered as what? Considered as the occupier. For few matters, it is the owner of the dock who is considered as occupier, and for few other matters it is the dock owner, the ship owner, who is considered as the occupier. In Containers Corporation of India Limited versus Lieutenant Governor Delhi, it was held that in the case of a company which owns a factory, it is only one director of a company who can be notified as what? Occupier, not all directors. So any one director can be notified as what? Occupier. In Indian Oil Corporation versus Labour Commissioner, it was held that for the purpose of section number 2 subsection subclause N, what is to be seen is who has the ultimate control over affairs of the factory. Relevant provisions regarding establishment of Indian Oil Corporation Limited and its working leave no doubt that ultimate control over all the affairs of the corporation, including opening as well as running of the factories, is with whom? With the central government. So if central government is having the control, then central government is considered as what? Considered as the occupier, and they are the one who is required to provide the what? Adequate measures. Okay, so we can discuss this chapter. One second, give me a second, I will get a notes for this. Okay, just give me a second. Yes, welcome back. So we have discussed this. Introduction is done. We discussed important definitions, that is competent person as well as hazardous process. We discussed what is hazardous process as per the Factories Act. Then we also discussed what are manufacturing process and what have been held as to be a manufacturing process. Then we also discussed who is a worker. Then we discussed definition of a factory. What is considered as factory, what is not considered as a factory, what is included, what is not included. Then we discussed, just now we discussed the definition of what? Occupier, correct, right? So for the factory, who is an occupier? The person who has ultimate control over the affairs of the factory is considered as what? Occupier. In case of partnership firm or association of individuals, it's the partners or members thereof. In case of company, any one or director of a company. If it is a factory owned by central or state government or local authorities, then the person or persons appointed to manage the affairs of the factory is considered as what? Considered as a occupier. In case of ship which is being repaired, on which maintenance work is being carried out in a dry dock, which is available for hire. Hire means you can take it for rental basis and you can carry out the repair work. In that scenario, the owner of the dock shall be deemed to be the occupier for the following purposes. That is, for approval of licensing and registration of factories, it is the owner of the dock. Notice by occupier for commencement of business, owner of the dock. 7A, general duties of occupier, the owner of the dock. 7B, general duties of manufacturers, etc., owner of the dock. Cleanliness, it is the dock owner's responsibility. Disposal of waste and effluents, owner of the dock is responsible, that is, he is considered as the occupier. Providing lighting facilities at the place of in the dock, who is responsible? Occupier is responsible, that is the dock owner. For rest of the things, that is section number 18, 19, 42, 46, 47, 49, which deals with drinking water, latrines, urinals, washing facilities, canteen, shelters, restrooms, lunchrooms, welfare officers. For the appointment of compliance of these things, who would be responsible? Dock owner only responsible. The owner of the ship is agent or master or other officer in charge of the ship or anyone who contracts with them will be responsible for the following, that is, ventilation and temperature. Duty of whom? The owner of the ship. Dust and fume, owner of the ship. Overcrowding, owner of the ship. Safety measures, it should be the duty of the owner of the ship. Then working hours of adults, it belongs to the owner of the ship. Employment of young person. So for the compliance of these provisions, who will be the owner? Who is the occupier? The owner is the occupier. Okay, yes. So they may ask question in the examination. Definition of an occupier from the which point of view? From the factory's point of view. And this definition will change from law to law. In one law, occupier means different. Other laws, occupier means different. Okay, yes. So if it is a partnership firm, who is the occupier? One of the partner. If it is a company, any one director of the company. If it is owned by government, then any person who is having ultimate control over the affairs of the business is considered as what? Occupier. And they are the one who will be held responsible for non-compliance. Done? Yes. Other important definitions. Adult means a person who has completed how many years of age? 18 years of age, but has not completed what? Not completed is 21 years of age. Then he is considered as what? Considered as adult. So anyone who is above how many years? 18 years is considered as what? Considered as adult. Adolescent means who has completed his 15 years of age. Any person who is above 15 but has not completed his 18th year, that is below 18, that person is considered as what? Adolescent. Adult means above 18 years. Adolescent means above 15 years but below how many years? 18 years. Then child means a person who has not completed his 15th year of age, means a person who is below 15 years. 15 years of age is considered as what? Considered as child. Means a person who has not completed his 15th year of age, below 15 years, is considered as what? Child. Young person means a person who is either a child or an adolescent is considered as young person. Day means a period of 24 hours beginning at midnight, because the day starts at midnight. Week means 7 days which starts at Sunday. Okay, which starts at Saturday midnight, means Sunday's starting is considered as the starting of the week. Power means electricity energy or any other form of energy which is mechanically transmitted and is not generated by human or animal agency. If it is generated by human or animal agency, for example, there are people who do this oil extraction by using the cow or animal, that is not considered as power. Or in a sense, electric energy or other forms of energy which is mechanically transmitted, that is called as power. Okay, yes. So these are the definitions, important definitions which are required for the understanding this chapter. So let us discuss the remaining provisions. General provisions. Notice by occupier, section number 6. Section number 6 provides the provision with respect to notice to be given to the chief inspector by an occupier. That is why definition of occupier is important. The occupier shall at least 15 days before. How many days before? 15 days before he begins to occupy or use any premises as a factory, send to the chief inspector a written notice containing the name and situation of the factory, the name and address of the occupier, the name of the nature of manufacturing process, and the details of workers, etc. All these things has to be mentioned and sent to whom? To the chief inspector in a written notice containing all these things. If a new manager is appointed at any time, the manager is changed, then the copy of the change shall be sent to the inspector along with the copy of the same should also be sent to whom? Chief inspector. Within how many days of appointment? Within 7 days. So when a person, occupier, starts production in a factory, he has to intimate the same to the chief inspector within 15 days, before 15 days of the before he occupies it. If there is any new manager is appointed, change of control, that shall be intimated within how many days? 7 days. Okay. During any period for which no person has been designated as manager of a factory, or during which the person designated does not manage the factory, any person found acting as manager, or if no such person is found, the occupier himself shall be deemed to be the manager. So factories may have a manager of the factory. If there is no manager, occupier himself is considered as a manager. If the occupier is not there, then whoever exercising the control as a manager will be held responsible. Section number 7. Notice by an occupier. General duties of an occupier, section number 7A. Every occupier shall ensure, so far as it is reasonably practicable, the health, safety, welfare of all the workers while they work at what? In the factory. It is the duty of the occupier to ensure the health, safety and welfare of all the workers. Then we have inspector, section number 8. As per this, inspector means the state government may appoint such person as prescribed to what? To act as a inspector for the purpose of this act, and may assign them such local limits as it may think fit. Powers of inspector, section number 8 है. Section number 9 deals with powers of inspector. Important, they may ask question in the examination. 7A, notice by occupier. 8, inspector. State government may designate a person as inspector to carry out the inspection of a factory, assigning him a jurisdiction. Powers of this inspector, section number 9. He can enter into any place which is used, which has reason to believe it is used as a factory. Make examination of the premises, plant, machinery, article, substance. Inquire into any accident or dangerous occurrence, whether resulting in a bodily injury, disability and are not, and take on the spot statement of any person which he may consider necessary for such inquiry. He can enter any place which is called as factory, make examination over there. What he can examine? The premises, plant, machinery, article as well as substance. He can inquire about any accident or dangerous occurrence which happened. For that purpose, he can inquire the person who are present there. Require the production of any document with respect to the factory from any person. He can seize or take a copies of registrar, records or any other document of any portion thereof as he may consider necessary. He can also take possession of any article for the purpose of carrying out any examinations, lab test. So these are the powers of inspector of a factory. They may ask this question in the examination, section number 9. Okay, 7A, 8, section number 9. 8 provides the state government can recognize a person as inspector, and he has this following part, section number 9. Certified surgeon, section number 10. Who are certified surgeons? Certified surgeons are the one who has been identified by the state government, who will certify that a young person is competent to work. Only a person who is certified by the certified surgeon can work in the factory if he is a young person. And who is young person? Above 15, below 18 is considered as what? Young person. Okay. State government may appoint a qualified medical practitioner to be certifying surgeons. For the purpose of this act, within such local limits or for such factory or class or description of factories as it may assign to them respectively. The duties of certified surgeon: the examination and certification of young person. As I said, who will certify? Certified surgeon will identify the persons who are young person, and they will also give a certificate whether they are eligible to work or not. And they also carry out the examination of person engaged in the factories in such dangerous occupations or processes as may be prescribed. The exercising of such medical supervision as may be prescribed for any factory or class or description of the factory where cases of illness have occurred, which is reasonable to believe are due to the nature of manufacturing process. So they can carry out the supervisory work on any factory or description of factories where there is a hazardous, there is an event of occurrence of any illness to the employees over there. So they do examination of young person, examination of purchase engaged in the factories, and they also carry out medical supervision of the alleged illness of the employees. These are the provision with respect to certified surgeon. By reason of any change in the manufacturing process carried out, or young persons are about to be employed in any work which is likely to cause injury to their health, so they can inspect these kind of premises. Okay, they may ask questions in the examination with respect to certified surgeon. Now, as I said, Act provides certain measures to be taken by whom? Occupier of a factory with respect to the workers employed in the manufacturing process. First one is health measures. Section number 11 provides cleanliness. It is the duty of the occupier to make sure that the factory is maintained cleanly. For this purpose, factory shall be kept clean and free from each effluvia arising from such any drain, privy or any other nuisance. Removal of accumulated dirt and refuse on floors, benches of workroom, staircases and passages, and effective disposal of the same. It has to be removal of dirt and fumes to be done. Cleaning of the floor of every workroom once in a week. This is important. The floor of the factory shall be cleaned once in every week by washing with disinfectant or by some other effective method. So washing of the floor is compulsory once in a week. Okay. Next one, interior walls and roofs. Whitewash or color wash should be carried out at least once in every period of how many months? Once in every period of 14 months. How many months? 14 months. whitewash or color wash should be carried out at least once in a period of 14 months for the interior walls. What was interior walls? Then where surface has been painted or varnished, then it has to be repainted or varnished at least once in every 5 years. Okay, painting of these walls 14 months once, then floor once in every 5 years. If it is washable, then once in a period of 6 months it has to be carried out. Where there are painted or varnished, where they have smooth impervious surface, in that scenario it has to be cleaned once in every period of how many months? 14 months. They may ask what are the cleanliness measures, health measures to be taken by the occupier. Washing should be done once in every week. Whitewashing of the interior walls once in every 14 months. Okay, and surfaces once in every 5 years. All the doors, windows, other framework which are of wooden or metallic shall be painted or varnished at least once in every period of 5 years. Okay, so these are the provisions with respect to interiors. Disposal of waste and effluent. There should be an effective arrangement for disposal of the waste and effluents accumulated in the manufacturing process. Ventilation and temperature. Suitable provision shall be made for maintenance of ventilation and temperature. Dust and fume. In every factory, emitting the dust and fume or other impurity of such nature in the process of manufacturing, and it is likely to injurious to the workers employed, then effective measures shall be taken to prevent its inhalation and accumulation in any workroom. Exhaust appliance shall be applied. Important. Exhaust appliance shall be applied if there is a dust and fume. Artificial humidification. If the humidity of the air is artificially increased, the state government may make rules for what? Prescribing the standards of humidification, regulating the methods used for artificially increasing the humidity of the air, directing prescribed tests for determining the humidity of the air to be correctly carried out and recorded. So the state government can make rules with respect to artificial humidification. Next one, overcrowding. If in the factory, it is the duty of the occupier to make sure that it is not overcrowded. One more health measure. Okay, no room in any factory shall be overcrowded. There shall be in every workroom in a factory at least 14.42 cubic meters of space. Important here, they may ask in the MCQs. What is the space to be maintained? At least 14.2 cubic meters of space to be maintained between the workers worked in the in the factory. Overcrowding. Next, lighting. There shall be a proper arrangement for lighting either by natural air or artificial or both, and there should be a provision for maintaining avoidance of the glare. Drinking water. There should be effective arrangement shall be made to provide and maintain at suitable points conveniently suitable for all workers employed a sufficient supply of what? Wholesome drinking water. Wholesome drinking water facility shall be provided. Where more than 250 workers are employed, a provision shall be made for cool drinking water. They may ask in the examination, when providing cool drinking water is mandatory by an occupier if there are more than how many workers employed? More than 250 workers are employed in a factory. And this water point shall be away 6 meters from the washing places, washrooms. So you have to provide cool drinking water facility if there are more than 250 workers are employed, and they shall be kept at least 6 meters away from any washing place, urinals and latrines as spit-off. Latrines and urinals. Sufficient latrine and urinals accommodation of prescribed types shall be provided. Sweepers shall be employed to keep clean the latrines, urinals and washing places. If there are more than 250 workers are employed, all the latrines and urinals accommodation shall be of prescribed type. Who can prescribe this? State government can prescribe with respect to the latrines and urinals of factory having 250 workers or more. Spit-ons, there shall be provided sufficient number of spit-ons in the convenient places and they shall be maintained in a clean and hygienic condition. So these are the measures to be taken by the occupier with respect to health. Washing facilities, then cold drinking water facilities. It should not be overcrowded. It should be a gap of at least how many cubic meters? Should be 14.2 cubic meters. Then we have safety measures. The Act prescribes the procedures to be adopted on the safety of the working place in a factory. First one, fencing of machineries. The machineries of the factories should be fenced properly so that no employee will approach it and get injured by that. So there should be fencing of premises, machineries. Work or near machinery in motion. So no persons, there should be proper safety measures to be provided for a person working in near the machinery which is in motion. Employment of young person on a dangerous machines should not be allowed. Striking gear and devices for cutting off the power should be kept near to the machinery. Self-acting machine should be properly checked. Casing of new machinery to be done. If it is a new machinery, it should be properly cased so that they don't damage or injure any person. Prohibition of employment of women and children near cotton openers should not be allowed. Lifting machine chains, ropes and lifting tackles should be done properly. Revolving machinery should be treated. Floors, stairs and means of access should be properly secured with safeties. Pits, stumps and openings in the floor etc. should be properly covered. Next one, excessive weight should not be allowed. Protection to the eyes should be given. Precaution against dangerous fumes and gases to be taken. Explosive or inflammable dust, gas, etc. There should be precautions with respect to what? Explosive as well as inflammables. Precaution in case of fire, there should be a fire safety measure. Safety on the buildings and machineries, maintenance of building. So these are the safety measures to be taken by whom? Taken by the occupier towards the workers. Appointment of safety officers wherein 1000 or more workers are employed. Important hai. Again they can ask when appointment of safety officer is compulsory. Wherever 1000 or more workers are ordinarily employed or wherein in the opinion of state government any manufacturing process or operation is carried on which process or operation involves any risk of bodily injury, poisoning or disease, then occupier shall, if so authorized, required by the state government by notification in the official gazette, employ such number of safety officers as will be specified in that particular notification. So appointment of safety officer is mandatory where there are 1000 or more workers, or it can be voluntarily done by the occupier, or central government may order for a person to appoint a safety officer. Okay, they may ask this question in the examination when safety officer appointment is compulsory. Okay, then we have a provision with respect to hazardous process. What process? Hazardous process. We have discussed what are hazardous industries or hazardous activities. Any manufacturing process specified in the schedule 1 and the raw materials used, intermediate products, finished goods or byproduct, effluents or wastages, if they are not handled with care, due care, they may escape and cause injury to the person's health, or it may pollute the environment. Then it is considered as what process? hazardous process. The state government may, for the purposes of advising it to consider application for the grant of permission for the initial location of a factory involving a hazardous process or for the expansion of any such factory. Okay, state government may, for the purposes of advising it to consider application for grant of what? Permission for initial location of a factory involving hazardous process or for the expansion of any such factory. Okay, so any person desires to start hazardous process, he has to apply to the government. Appoint a site appraisal committee. So there is a committee called site appraisal committee which gives the permission for starting an hazardous process. So if any one of us want to start an hazardous process, we must apply to whom? Site appraisal committee. The site appraisal committee shall examine the application for establishing of a factory involving hazardous process and make its recommendation to whom? To the state government within 90 days of receipt of such application. So you make application to site appraisal committee, that forwarded to whom? To the state government after examination. Within how many days of receipt of application? 90 days. The committee has the power to call for any information from the person making an application. When the application is got approved by the state government, it shall not be necessary to obtain further approval from central board or state board of pollution authorities. Once the state government gives the approval, it's an omnibus approval, means approval is given by all authorities. So there is no need to go for again this water board or pollution board for permission, not required. Responsibility of the occupier. The occupier has the following responsibilities when he starts the hazardous process. Simple. Before he starts hazardous process, he has to intimate this to whom? To the site appraisal committee. That site appraisal committee forward the application to state government. Then the state government gives the approval. Okay. What are the responsibilities of that appraisal, the occupier? To lay down the detailed policy with respect to health and safety of the workers, to disclose all information regarding dangerous, including health hazard, measures to overcome such hazards arising from the exposure to or handling of materials used in the manufacturing process, to draw up on-site emergency plan. If something happens, what is the emergency plan he has to save the workers as well as the people within the vicinity. So they have to make a plan for emergency evacuations. He has to lay down the measures for handling usage, transportation and storage of hazardous substance. Then he has to maintain the health record of employees. Then he has to appoint experienced persons who possess specified qualification in handling hazardous substance. These are the duties of the occupier carrying out hazardous process. They may ask this question in the examination. And also about site appraisal committee. Powers of central government, section number 41D provides that central government is having power to inquire to the standards of health and safety observed by factories. So central government has the power to carry out the investigation. 41E provides emergency standards in respect of what? Respect of a factory. What are the emergency standards to be maintained by the factory? 41F provides fixing the maximum permissible threshold limit of exposure of chemical and toxic substances in the manufacturing process in the factory. 41G provides that occupiers shall set up a safety committee. What committee? Safety committee consisting of equal number of representation of workers and the management to promote what? Cooperation between the workers and the management. 41H provides that workers have a reasonable apprehension that there is a likelihood of imminent danger to their lives or the health due to the accident. They may bring the same to the notice of whom? Occupier, agent or manager. So these are the powers of the central government or the state government. Okay. So out of this appraisal committee, site appraisal committee for carrying out hazardous process is important to ensure the safety. Then we have welfare measures, Chapter number 5 provides the welfare measures to be taken by whom? Taken by the employer. Important. First one, washing facilities. Every factory shall provide adequate and suitable facility of what? Washing. The washing facility shall be conveniently accessible and shall be kept clean. Facilities for storing and drying clothing. State government to make rules with respect to providing suitable places for keeping clothing not worn during the working hours and for drying of wet clothing. Facility for sitting, there should be a proper facilities for sitting if the work is carried out in a standing position. First aid appliances, important, they may ask when maintaining of first aid appliances is compulsory. The number of such boxes, that is cupboards equipped with prescribed content, should be kept in the factory. The number of such boxes or cupboards should not be less than one for every 150 worker. So you have to keep a safety this one box for every one worker, one box for every 150 workers. In a factory where more than 500 workers, most important, if there are more than 500 workers are employed in any factory, an ambulance should be kept by the company or occupier. Okay, next one, canteens, important hai, if more than 250 workers are employed. Drinking water facility 250 or more, but it is, this one is if more than 250, means 250 plus 1. So in that scenario, if more than 250 workers are employed, it is mandatory to have a canteen facility in the factory. Okay, next, Ferrous Alloys Corporation Limited versus State of Andhra Pradesh. The court held that canteen facility can be provided either directly or through an employment of contractor. Either you can provide it directly or through some contractor. If it, in case it is provided through a contractor, the workers in the canteens are not considered as what? Employees of the factory. They are separate. Shelters, restroom and lunchroom shall be provided if there are more than how many workers employed? More than 150 workers are employed. Crutches, if more than 30 women workers are employed, they shall be provided and maintain a suitable room for the use of children under the age of what? 6 years of such women. Okay. So if there are 30 women workers are employed, there should be a crutches for treating whom? Treating the kids who are the age of 6 years. Okay. Welfare officer, important, they may ask. Safety officer, where there are 1000 or more workers are employed. Welfare officer's appointment is compulsory when there are 500 more workers are employed. So these are the safety, health and welfare measures to be taken by whom? Taken by the occupier. So we discussed who is an occupier, what are the safety, health and welfare measures to be taken by him in the factory. Okay. Then we have second set of provisions which deals with the working hours of the adult as well as the young person and the woman. Let us discuss that. Important hai. No adult worker shall be required or allowed to work in a factory for more than 48 hours in a week. So the maximum number of hours a person is required to work is 48 hours in a week, not more than 48 hours. Okay. Daily hours in a week, 48 hours. Daily he is not required to work for more than 9 hours in any day. Okay. So the maximum number of hours a person is allowed to work in a factory is what? Not more than 9 hours. Maximum is 9 hours. Next. Spread over the periods of work of an adult worker in a factory shall be so arranged that inclusive of his interval for the rest, they shall not spread over more than 10.5 hours in any day. Means the time he spends in the factory shall not go beyond 10.5 hours including his break. So in a day 9 hours, in a week it is 48 hours in any week. Intervals for rest, a period of work shall not exceed 5 hours at a stretch. A person can be allowed to work for only 5 hours at a stretch, and after that he shall be provided with an half an hour rest for working hours for 5 hours. Weekly holidays, no adult worker shall be required or allowed to work in a factory on the first day of the week. No adult worker shall be required or allowed to work in a factory on the first day of the week, Sunday. That should be an holiday, but with the permission of the state government they can provide alternative holiday. If there is alternative holiday, then they may make work for person to work on Sundays also. Okay, he has or will have a holiday for a whole day on one of 3 days immediately before or after Sunday. Okay, so either next day or preceding day shall be holiday. If that is the case, then he can be made to work on Sunday. These are the provision with respect to working hours of adult. What is the first one? Weekly hours is how many hours? 48 hours in a week. Daily 9 hours. Intervals for the rest, after 5 years there should be a half an hour break. Spread over, should not go beyond 9.5 hours, and there should be a weekly holiday on Sunday. Okay, so you have to provide, if Sunday is a working day, then you have to provide preceding 3 days or preceding after succeeding 3 days में एक day तो देना पड़ेगा as a holiday. The manager of the factory delivered the notice about the same to the inspector, display the notice to that effect in the factory. No substitution shall be made which will result in any worker working for more than 10 days consecutively without a holiday for whole day. There can't be a situation where a person is made to work for more than 10 days without a break. That is the maximum time allowed. Okay, yes. Motor and Machinery Manufacturers Limited, what was the state of West Bengal? It was held that primary object of section number 52 is to provide a weekly holiday for the workers, and such day was fixed to be the first day of the week, that is Sunday. But for any special reasons, it become necessary to make Sunday the working day. A substitutional holiday is made compulsory. That holiday should be what? Either preceding 3 days before Sunday or succeeding 3 days after the Sunday. But a person cannot be made to work for more than 10 days without a break. Compensatory holidays, if a worker is deprived of any of the weekly holidays, he shall be allowed within the month in which the holidays were due to him or within 2 months immediately following that month. Compensatory holidays of equal number to the holiday so lost shall be given. If there is a national holiday and if you work, then on that, for that purpose, you get what? Compensatory holiday in the same month or within the next 2 months. Night shift, where a worker in a factory works on a night shift which extend beyond midnight for the purpose of weekly holiday and compensatory holiday, a holiday for a whole day shall mean in case of period of 24 hours consecutive hours beginning when his shift ends. Means there are people who work whose day starts on Sunday night. For them, holiday means the day starting on the Saturday night. 24 hours should be taken into consideration. Prohibition of overlapping shift. There can't be an overlapping shift, means where you are supposed to work immediately. There should be a holiday before you start a shift. Let's say some people works on night shift, then morning shift. Before the shift changes, there should be what? Gap. There should be a holiday. That is a one more provision with respect to what? Working hours. Extra, which is for overtime. Where a worker works in a factory for more than 9 hours in a day or for more than 48 hours in a week, he shall, in respect of overtime work, be entitled to wages at the rate of twice his ordinary rate of wages, double payment. Where a workers work in a factory for more than how many hours? Maximum 9 hours, right? Hello? And the maximum spread shall not go beyond how many hours? 10.5 hours, including the break. For more than 48 hours in any week, he shall, in respect of overtime work, be entitled to wages at the rate twice his ordinary rate of wages. He is supposed to get a double payment. Ordinary rate of wages means basic wages, allowances, cash equivalent, but does not include bonus and wages for overtime work. Double employment, no adult worker shall be required or allowed to work in any factory on any day on which he has already been working in any other factory. Not allowed. Double employment is not allowed. Register of adult worker, the employer shall maintain the register of adult worker specifying his name, nature of work, the group which where his group works on shift, the relay to which he is allotted. All this has to be maintained in the register of adult workers. They may ask questions in the examination with respect to provisions with respect to adult workers timing. Okay, so an adult worker cannot be allowed to work for more than how many hours in a day? 9 hours. At any time, it shall not exceed how much? Including break, 10.5 hours. Correct now? So they may ask these questions in the examinations. Be careful. Next one, employment of women. Can women be employed? Yes. Daily hours same like adult worker, 9.5 hours. 9 hours. Sorry, 9 hours. Unlike male adult worker, no exemption can be granted to whom? Women. Means there are exceptional cases where the male person can work and they can get a extra payment, double payment. But there is no question of double payment for whom? Women. Women cannot be made to work beyond the prescribed number of hours. Working time, no woman shall be required or allowed to work in any factory except between 6 am and 7 pm. So women cannot be employed before 6 am or after 7 pm. Okay. No woman shall be required or allowed to work between that time, but with the permission of the government, they can be made to work beyond the 7 pm also. Change of shift, they can't be change of shift without an holiday between the change of shift. Next, employment of young person, a important type. Employment of young person. What about night shift? Yes, she can be allowed to work only with the permission of central government or state government in the factories, not in the ITBT. ITBT it is allowed. Only in the factories. Factories Act deals with factories where what is carried out? Manufacturing activities carried out. Okay, yes. Employment of young person. Prohibition of employment of young person. No child who has not completed his 14th year shall be required or allowed to work in any factory because he is a child. A factory made child cannot be allowed to work. But can a young person be allowed to work, sir? Yes, if he is certified by the certified surgeon. No adult workers to carry token. Sorry, non-adult workers means if he is a young person, he has to carry a badge specifying his age, all these things. Child who has completed his 14th years or an adolescent shall not be required or allowed to work in any factory unless a certificate of fitness granted in the custody of the manager of the factory. Means he shall take certificate of fitness from the certified surgeon and the same shall be submitted to whom? Manager. Such child or adolescent carries while he is at work a token giving a reference to such certificate that he is a certified person. Certificate of fitness, certifying surgeon. We discuss who is certified surgeon. On the application of any young person, his parent or guardian, accompanied by documents signed by the manager of the factory, that such person will be employed therein. If certified to be fit for work in a factory, or on the application of a manager of the factory in which any young person wishes to work, examine such person and ascertain his fitness for the work in the factory. A certificate of fitness to work in a factory as a child if he is satisfied that young person has completed how many years of age? 14th years of age, because below 14 years you can't work. And he can be certified to work as adolescent if he is above how many years? 15 years. So child is different, adolescent is different, young person is different. Young person includes both the person who is above 14 years and person who is above 15 years. But above 15 and below 18 years considered as what? Adolescent. Okay. Working hours of children, half of these majors. What is a adult worker can work for? 9 hours in a day, but for minor it is 4.5 hours. The period of work for all children employed in a factory shall be limited to 2 shifts, which shall not overlap, spread over more than 5 hours each, maximum 5 hours. No female child shall be allowed to work in any factory except between 8 am and 7 pm. 8 am and 7 pm. So, women worker 6 am and 7 pm, but female child worker 8 am to 7 pm. Register of child worker, the employer shall maintain the register of what? Child worker, specifying the name of the child, nature of his work, the group, the number of his certificate of fitness granted. Okay, these are the provision with respect to what? Employment of a young person. This part is important. Annual leave with wages, where a factory shall provide leave with wages. With wages, how many? Every worker who has worked for a period of 240 days in a year shall be allowed leave with wages for number of days calculated at a rate of, if an adult, 1 day for every 20 days of work performed by him during the previous calendar year. If he has worked for minimum 240 days, how many days? 240 days. Then he is eligible for leave with wages. 1 day for every 20 days of work performed by him during the calendar year. If he is a child, 1 day for every 15 days of work. For the purpose of computation of 240 days, because only when you have worked for 240 days or more, you are eligible for leave with wages. Otherwise, you are not eligible. Following shall be included: any day of layoff by agreement or contract as permissible under the Standing Orders Act. Layoff shall be taken into consideration. In case of female worker, maternity leave for any number not exceeding 12 weeks should be considered as number of working days, because maternity leave is considered as deemed employment. The leave earned in the year prior to that in which the leave is enjoyed should be taken into consideration. And last one is, in calculating the leave, fraction of leave of half day or more shall be considered as what? Full day leave, and fraction less than half a day shall be omitted. So, if a worker has worked for minimum 240 days during a calendar year, then he is eligible for 1 day of the leave for every 15 days of work. If he is a child, adult, 1 day of paid leave for every 20 days of work. Carry forward of leave. Like, what if you have the paid leaves and you can't enjoy those paid leaves? If a worker does not in any calendar year take the whole of the leave allowed to him, any leave not taken by him shall be carried forward to the succeeding year, next year. The total number of leave that can be carried forward shall not exceed 30 days in case of adult, 40 days in case of child. Remember this, 30 in case of adult and 40 in case of child for carry forward of non-encased leaves. A worker who has applied for leave with wages but has not been granted shall be entitled to carry forward the leave refused without any limit. If it is voluntarily not enjoyed, they can only carry forward 30 and 40. A worker may at any time apply in writing to the manager not less than 15 days before, and if it is public utility services, 30 days before, to take all the leave or any portion thereof allowable to him during the calendar year. If you want to take a leave paid leave, you have to give a 15 days prior notice, and 30 days if it is a public utility service. Wages during the leave period. A worker shall be entitled to the wages at a rate equal to the daily average of his total full-time earnings for the days on which he actually worked during the month immediately preceding his leave. It has to be paid proportionately. Advance payment. A worker who has been allowed leave for not less than 4 days in case of an adult and 5 days in case of a child shall before his leave begins be paid the wages due for the period of leave allowed. He can be paid the advance leave. Encashment of leave. This also helps you in the income tax. If a worker is discharged or dismissed from the service or quits his employment or is superannuated, superannuated means he achieved that age, or dies while in his service during the course of the calendar year, he or his legal heirs or nominee shall be entitled to the wages in lieu of quantum of leave to which he is entitled immediately before such termination of his services. Means he can get the payment for that leaves which he could not enjoy, and this payment shall be made before the expiry of second working day from the date of discharge or dismissal or quitting, and where the worker is superannuated means he achieved the age of retirement, then before the expiry of 2 months from the date of such superannuation or death. So if it is dismissal, within 2 days, if it is superannuated, within 2 months. If any of the provisions of this act are not complied with, then there is a penalty for contravention. The occupier and the manager of the factory shall be each guilty of an offence. They will be liable for an imprisonment of which may extend to 2 years or a fine which may extend to 1 lakh or with both. If the contravention is continued after conviction, with a further fine which may extend to how much? 1,000 for each day on which the contravention so continues. If the contravention is resulted in an accident causing a death or serious bodily injury, the fine shall not be less than how much? 25,000 rupees, and 5,000 rupees in case of accident causing serious bodily injury. Okay, it is not 5,000, it is 50,000. Okay, 1 0 is missing, you can just add it. Enhanced penalty. If the same offence is repeated, then the penalty will be how much? 3 years of imprisonment, and also fine which will not be less than 10,000 but which may extend up to 2 lakh rupees. Penalty for obstructing inspector when you go for inspection, 10,000 rupees penalty. Penalty for contravention of the provision with respect to hazardous process, remember section number 7, notice by the occupier, 7A, then he would be liable to a penalty of fine which may extend to 2 lakh, and per day 5,000 rupees during such default. Offence by workers, 500 rupees. Penalty for using any false certificate, then he is punishable with a penalty of 1,000 rupees or imprisonment for a term which may extend to 2 months. Penalty for permitting double employment of a child, 1,000 rupees. So these are the penalty provisions for compliance of non-compliance of Factories Act. So let us just go through the materials once and see whether we have covered everything or not. Yes, we have covered everything, but just we'll go through it once. Okay, yes, 1 second. Yes, Factories Act 1948, definitions we have discussed, occupier we have discussed definitions, duties of occupier I discussed, inspector I discussed section number 8, correct now? What are the powers of inspector? Have I discussed powers of inspector? We discussed, right? What he can do, he can enter, We can take samples, we can carry out investigation, discuss किया हम लोग. Then have I discussed certified surgeon concept? Yes. Welfare measures have I discussed? Welfare measures to be taken by the employer. Health measures हम लोग discuss किया. Then this one, cleanliness, disposal of waste and effluents, ventilation, dust and fume, हम लोग इसको डिस्कस किया with respect to these things. Then drinking water, lighting, latrines and urinals. Then we also discussed about safety measures, hazardous process. Have I discussed hazardous process? Yes, इसको हम लोग डिस्कस किया. Then we discussed about welfare measures. Then we also discussed about washing facilities, first aid appliances, 150 workers, then canteens, shelters, creches. Then we discussed about working hours of adult. What is the working hour? What is the working hours? Per day, how many hours he can work? Per day, maximum how many hours? An adult worker can be made to work for more than, can be made to work for more than 9 hours in a day? No. And the spread shall not go beyond 10 and a half hours. Correct na? So all these things we discussed. Weekly holiday provisions I have discussed. Case study, double employment, shift duty, overtime, register of adult workers we have discussed. Employment of women as well as employment of young person. Can we employ a woman between 6 a.m. to 7 p.m.? They can be employed to work only between 6 a.m. to 7 p.m. Can she be employed before 6 p.m.? No. State government may authorize the employment of any woman between what? 10 p.m. to 5 p.m. Allowed only if central state government authorizes it. Employment of young person we discussed. Certificate of fitness we have discussed. Then we also discussed about working hours of children. Annual leave with wages. Have I discussed annual leave with wages? 1 day for every 20 days, 1 day for every 15 days in case if he is a minor. इसको हम लोग डिस्कस किया. Carry forward, advance payment, penalties. Have I discussed penalties for non-contravention of the provisions? Yes, we have covered everything out of the material. Are we clear with this chapter? Everyone, I'll share the notes to you guys today. Yes. Age of adolescent worker is how many years? Adolescent 18. Above 15, below 18 is considered as what? Adolescent. Correct? No, sorry. Above 15, below 18 is considered as adolescent. Certificate of fitness to be young person worker is granted by A, B, C or D. What is the answer? Question number 2. Certifying surgeon. Correct. Whitewash or color wash should be carried out at least once in every period of how many months? 14 months. Where more than dash workers are employed, provision shall be made for cool drinking water during the hot weather. 250. B. Correct. Shelter rooms with suitable lunch rooms are provided if more than dash workers are employed. Shelter rooms. 250. No female child shall be allowed to work in factory except between 8 a.m. to 8 a.m. to 7 p.m. Correct. There are a few other questions, you guys can just go through it. Okay, isko solve kar lena. So we are left with gratuity act is there that I will discuss in tomorrow's class. We will discuss, not tomorrow, Monday we will discuss gratuity, one chapter, then PF chapter. We will discuss 2 chapters. Then we have ESI and code of wages. This will take 1 class. So I will take 2 more classes for 2 or 3 more classes for labor laws. Okay, for discussing these chapter. Once labor laws are done, we will discuss the which chapter? Ethics chapter. So next week excluding your festival. I will I will take the classes. And one more thing, one second before